My lords,
And find permission. This matter is pertaining to my lords that running a fair fry shop that was fair fry shop that was suspended by the my lord deputy director of food civilian. It was listed on last week, but it was listed on 20.
ನಾಳೆ ಆಗ್ಬೋದಾ? Pending matter.
20 ಏನಾಗಿದೆ ಅಂದ್ರೆ they want to take a initiate action to call for tender.
ಅದು ಕರೆದಾಗ
Monday.
Monday or Tuesday will take it.
my lords, this is a fresh GST matter. My goods are apprehended and detained since 4th October. It may please be posted.
4th October.
4th October.
Monday. Election. ಎಲ್ಲ disposal.
My lord, serial number 144, income tax matter, my lords, faceless matter. Yes, my lords, except annexure B, all other may be quashed, my lords.
AC. Bill number 144. Faceless ಅಂತ ಬರ್ಕೊಳ್ಳಿ. ನಾನು ಮಣಿ ಕೇಳಿ ಚಿಂಬರ್ಲಿ. Except annexure B.
B, my lords. B.
Except annexure B. All other annexures squashed.
Grateful.
One matter tomorrow for being spoken.
Why?
Correction of interim day after yesterday.
Day after yesterday alla. Day before yesterday.
Day before yesterday interim order is in past. Wherein providing alternate job to the petitioner. But in fact, earlier he was not working as a in the alternative job. For the first time, his request for alternative job has been rejected.
Being spoken.
Cooperative election matter for declaration of results, my lords, at 2:30. Please.
Serial number 85, your lords.
Adjournment.
Yes.
Mentionment is called. ಇಲ್ಲೇ ಇರ್ತೀರಲ್ವಾ?
Please.
With my lord's kind permission, my lords, may I please mention a matter of the Bengaluru bench, my lords?
Yes, Varun,
Please, my lords, grateful. My lords, these are two CRPs which my lords have heard. And my lords, in so far as the grievance of the petitioner before my lords, it has nothing to do with the plaintiff. He says co-defendant counterclaim not maintainable, but my suit is
Which
stayed.
CRP?
679 and 680 of 25 minutes. Any date that my lords finds convenient.
We'll post it on Friday.
I'm grateful.
Yes.
Humble submission, my lords. The GST matter may please be posted tomorrow.
ನಾಳೆ ಬೇಕಾ?
Please. Please, madam.
Hold this.
Serial number 1, Naveen Chandra.
So, in this case, the application filed by the dependent for stay of suit has been rejected. Against that, your worship, the petition is before some court. Your worship, the respondent is the husband. He filed
The petitioner is before this court calling in question an order dated 4/12/2017 passed on IA3 in OS 18 of 2016. The petitioner heard the learned counsel appearing for the petition. The respondent party in person has remained continuously absent. Therefore, this court, therefore the matter is heard. The counsel for the petitioner is heard, and the subject petition is disposed. The facts in brief, germane, are as follows. The petitioners are wife and the child of the respondent husband. The respondent husband is said to have filed a suit in OS 302 of 2015. Yen declaration?
So me.
Yen declaration?
To declare that the dependent number 2 is not born to the dependent.
Files a suit for declaration, seeking to declare that the second petitioner, the child born from the wedlock, was indeed not born from the wedlock of the petitioner and the respondent. The said suit is pending consideration before the concerned court at Hirekerur. Notwithstanding the pendency of the said suit, the husband is said to have instituted another suit in OS 18 of 2016 before the concerned family court at Hubballi for the same declaration between the same parties. Therefore, the petitioner files an application in IA3 under section 10 of the CPC seeking arrest of the suit in OS 302 of 2015 in the light of the subsequent suit filed for the very purpose, for the very same relief between the same parties. The concerned court has rejected the application filed in IA3, and therefore the petitioner is before this court in the subject petition. The aforenarrated facts are not in dispute. The earlier suit filed in OS 302 of 2015 at Hirekerur, a family court was at the concerned court at Hirekerur was for the same purpose of declaration that the second petitioner was not born from the wedlock of the first petitioner and the respondent. The respondent. The second, the subsequent suit in OS 18 of 2016 is for the same prayer. Therefore, ಯಾವ್ದು ಬೇಕು ನಿಮಗೆ?
ಇದು ಹಿರೇಕೆರೆ ಸ್ವಾಮಿ.
Therefore, the subsequent suit should necessarily have merited, the application filed in the subsequent suit necessarily ought to have merited consideration, favorable consideration at the hands of the concerned court. In the light of the subsequent suit, in the light of pendency of two suits for the same relief, the suit in OS 18 of 2016, the proceedings in suit in OS 18 of 2016 shall remain stayed till the disposal of the suit in OS 302 of 2015. ಯಾವ್ದು ಬೇಕು ನಿಮಗೆ?
ಹಿರೇಕೆರೆ ಸ್ವಾಮಿ.
So ordered accordingly.
Serial number 2, C.S. Shettar, Ramchandra Mali.
Appealing for respondent number 2 in this matter.
Regularization.
Yes, Miller, but that has to be the endorsement issued by the respondent number 4. The respondent number 2 is nowhere concerned to this, just formal party.
Respondent number 2 ಯಾರು? 4 ಯಾರು?
Respondent number 2 is the University of Agriculture, Dharwad.
Yeah, where are you working, sir?
My lords, I have retired from the service from
Yeah,
respondent number
where
4.
were you working, sir?
Respondent number 4, my lords, Bidar University.
Respondent number 4 ಯಾರು? sir?
Bidar University.
Bidar
Veterinary.
University.
ಹೇಳ್ಬೋದು ತಾನೆ?
Veterinary
Veterinary.
Animal and Fisheries Science University. Veterinary Animal and Science Fisheries. University.
Veterinary
Animal
Fisheries
and
University.
Fisheries Science.
Bidar
University.
University.
Bidar University.
ಎಲ್ಲಿಂದ ಯಾವಾಗಿನ ಕೆಲಸ ಮಾಡ್ತಾ
My
ಇದ್ದೀರಿ?
lords, 1977, my lords, I was
77
I was employed as daily wage employee.
ಹಾ.
Subsequently, 1985, my lords, I was absorbed as a monthly wage rated employee. And my lords, I had remained absent from 94 to 96. There was
ಎಲ್ಲ?
94 to 96. That reference, my lords, is at page number 43.
Now who is to answer the petition?
My lords, respond number 4 served, my lords,
Served?
third.
Served unrepresented.
ಯಾವ ವರ್ಷ? 24 ಆಯ್ತು.
Please.
Only on the count, my lords, proceedings were pending. That's the reason I have not been, my regularization is not been considered from 94, my lords. 2005 anta consider ಮಾಡಿದೆ.
What proceedings were pending?
Proceedings, my lords, I had remained absent from 1994 to 1996. I was removed from the service. That was challenged before the labor court, and I was reinstated. That was challenged before this honorable court. 1994, my lords, to 1996. I was reinstated, my lords.
When were you reinstated?
My lords, by the order dated 1996, my lord. And 2004, 13/4/2004. That was challenged before this honorable court.
When did that get disposed?
My lords, that got disposed on 11th September 2007.
11/7
11/9/2007.
reinstate ಮಾಡಿದ್ರ ಆಮೇಲೆ?
Reinstatement.
When did you retire?
Condition 2018, my lords.
Condition ಏನು?
Condition was that, my lords, I am not entitled for, I read that, under the circumstance, petition filed by the university is allowed in part, and the petition filed
At
by the
page
claimant is
50, my
dismissed.
lord, that observation was made in the earlier writ petition. The honorable court has made observation, page 50, my lord. May kindly be seen last paragraph, at paragraph number 9. Under the circumstances, petition filed by the university is allowed in part, and the petition filed by the claimant is.
All right. Perfect.
This was considered, this has to be considered.
Yes, madam.
Your Lordship, as considered by the court, Your Lordship,
As considered.
because the respondent number 4 is to be
The- ನಿಮಿಷ.
The order will clarify, he is not entitled 50% back wages and then consequential benefits also. That order will clarify this, the order passed with this honorable court itself.
Don't worry. The petitioner,
I would like to take leave of this court.
please take.
Yes.
The petitioner is before this court calling in question the action of the fourth respondent university in declining to consider the case of the petitioner for regularization of his services, notwithstanding the fact that the petitioner has been in continuous employment for more than 10 years, as is necessary in terms of the relevant government orders, in terms of the government orders notified from time to time. Heard so and so, the facts and brief germane are as follows. The petitioner joins the service of the first respondent. Yeah, the first respondent.
First respondent, my lords,
First respondent, Department of Animal Husbandry and Fisheries on 19/3/1977. It transpires that the first respondent then regularized the first respondent then bought the services of the petitioner under nominal muster roll or a consolidated pay on a month-on-month basis. Owing to certain omissions and commissions, the petitioner was removed from service, which comes to be questioned before the Labour Court in Industrial Dispute 125 of 1996. The Labour Court, in terms of its award dated 13/4/2004, set aside the reinstatement, set aside the termination, directed reinstatement of the petitioner into services with 50% back wages. The said order of the Labour Court was called in question by the respondent state before this court. Writ petition yavudu?
please, my lords. Writ petition at Annex D, WP number 32828 per 2004. Annex D, my lords, page
In
number 41.
WP 32828 of 2004, the said writ petition comes to be disposed by the following order. Para 9 at page 50. The order of the Labour Court was modified to the extent of 50% of back wages, which would be that the petitioner was declared that he would not be entitled to 50% of back wages, but he would be entitled to the benefit of continuity of service, except for a period between 1994 to 1996. The 2 years he would not be entitled to any consequential benefits is what was ordered. The purport of the said order is that the petitioner, though, was removed from service in the year 1986, in the year 1986,
94.
1994, the said order being set aside and the coordinate bench of this court directing continuity of service to be granted would mean that the petitioner has been in continuous service. After the disposal of the writ petition in the aforesaid manner, it transpires that the petitioner comes to be reinstated into service on 11/9/2007, after which he works for about 11 years and retires on attaining the age of superannuation. By then, the fourth respondent had come into existence. In the light of the fourth respondent coming into existence, the services of the petitioner was handed over to the fourth respondent university. Therefore, he became the employee of the university, and on continuous basis right from 1976 till the date of his superannuation. In all, the petitioner has put in 40?
Please, my lords. 50 years. 40 years. 77.
18,
13,
20,
96.
40 years. Put in close to 40 years of service. The petitioner, during his service in the university, represents seeking regularization of his services as he was being left in the lurch at the time of retirement. This claim comes to be rejected. The claim comes to be rejected on the score that the petitioner had not completed 10 years of service at the relevant point in time. The learned counsel appearing for the petitioner would take this court through the government order dated 6th August 1990 to buttress his submission that the daily rated employees then who had worked for 240 days were all entitled to be absorbed, regularized into services with effect from 1/1/1990. 1/1/1990, and therefore the petitioner's service could not have been kept aside without regularizing. The learned counsel would submit that the dismissal order comes about in the year 1994, but in 2007 everything is restored status quo ante insofar as the so far as the continuity of service is concerned. In that light, the learned then visual Shettar order, mandamus.
Mandamus as well as
The regularization had not come about. Therefore, the petitioner had to again knock at the doors of this court in writ petition, page 111. The coordinate bench again quashed the endorsement that rejected the claim and directed reconsideration of the claim of the petitioner. The paragraph 10, page 118 to 120. Yet again, an endorsement that is impugned in the subject petition comes to be issued on the score that the petitioner is not entitled to regularization. In identical circumstances, this court in full Hakpudi. Following the judgment of all the judgments of the apex court, including the one rendered in August 2025, i.e., in the case of Dharm Singh versus State of Uttar Pradesh, has held as follows. The court Marabuto. In the light of the said judgment, as also the fact that the petitioner was entitled to continuity of service in terms of the order passed by the coordinate bench quoted supra, the claim for regularization of the petitioner cannot be denied on the specious plea that he was out of service for a particular point in time. That having been considered by the coordinate bench, and the consideration of which having become final, the university cannot now put the clock back and contend that the petitioner would not become entitled for regularization. In that light, the petition deserves to succeed. Allowed, quashed. The respondent shall now consider the case of the petitioner for regularization, bearing in mind the observations made in the course of the order, and pass necessary orders within 8 weeks from the date of receipt of the copy of the order. Please, order record.
Number 3, Madan Gowda and Patil, Prashant Usmani.
ಇದು ವಾಪಸ್ ಕೊಡಿ ಯಾರು ಸಮೃದ್ಧಿಗೆ ವಾಪಸ್ ಕೊಡಿ ಸಮೃದ್ಧಿಗೆ ವಾಪಸ್ ಕೊಡಿ
covered by judgment Chandrakant case.
ಕವರ್ಡ್ ಕೊಡಿ ಕವರ್ಡ್ ಅಲ್ವಾ
Copy, my lords, has been
not served.
ಪೆಟಿಷನ್ ಕಾಪಿನೇ ಕೊಟ್ಟಿಲ್ವಾ
There is a special order passed by this honorable court in the earlier occasion.
Served, my lord.
ಮುಂದೆ ಬನ್ನಿ ಸರ್.
My lord, there is a specific order passed by this honorable court to
That you
serve
should
the
not give a copy.
serve the copy and thereafter file objections.
ಇದು is there an order passed by this court that you should not give copy?
No.
ಕೊಡಿ
Please.
ಯಾವಾಗ
Pass over. Now today.
ಪಾಸ್ ಓವರ್ ಅದನ್ನ
Covered by
ಮಾಡಲ್ಲ ಕವರ್ಡ್
124.
ಅವ್ರು ನೋಡೋದ್ ಬೇಡವಾ?
Serial number 124, my lord.
Copy has been given just now, my lord. I will.
This is wrong.
Please, my lord.
When you want disposal, you should cooperate with the opposite side by giving copies at least. List after 4 weeks.
Pass over. Today, tomorrow, my lord.
List after 4 weeks. Copy kodi. Petitioner to serve complete set of papers upon the counsels appearing for the respondents. Objections, if any, by the next date. List the matter on 2nd December.
Next.
No, sir.
Serial number 124 also connected with this.
Okay.
Connected, same.
124. Tag this with 124. List on 4nd.
Next is request. I'll serve, your lordship. We don't also.
When there is a specific order by this court to serve copies, you don't serve. Move the matter saying it is covered,
It has been.
and you want this to be disposed. ನೆನ್ನೆಯಿಂದ ಇವತ್ತಿಗೆ ಬಂದಿದೆ ಹೌದಾ?
Money.
ಮೊನ್ನೆ ಯಾರು ಕೊಡ್ಬೇಕು ತಾನೆ ಕಾಪಿ?
Oversight.
Oversight.
Next. Short.
2nd December. Yes, that's not correct. Don't take the opposite side by surprise.
By oversight it is happened.
ಅದಕ್ಕೆ ಓವರ್ಸೈಟ್ ಏನಾರು ಒಂದು ಆಗ್ಬೇಕಲ್ಲ, ಅದಕ್ಕೆ 2nd December. 2nd January ಅಂತ ಹೇಳಿಲ್ಲ, 2nd December ಅಷ್ಟೇ.
At least 15 days.
Yes.
Number 4, MB Hiremat.
Lords, 3 more connected matters are there, my lords. And also, my lords, my request on Tuesday,
Why?
learned AG will appear in this.
AG or AG?
AG.
Double AG na? AG.
Double AG.
Double AG.
These two matters are not connected with that. I don't mind minutes.
It may be listed on the same day, my lords.
That will show their contact minutes on every occasion as to how they are trying to scuttle the minute.
Again, matter.
First matter relates to a mandamus to initiate action against the executive officer who has demolished the millet. There were certain pillars millets which were about 150 to 200 years old. He has millets, virtually millets brought the
old pillars anta ತೆಗೆದುಬಿಟ್ರಾ?
ಅಂದ್ರೆ ಮಂಟಪ ಇತ್ತು. That was dismantled and kept separate for the purpose to be used for the purpose of construction of a temple. Well, he has sold this millet. He has brought the entire.
Last time I said, who's that executive officer?
The executive officer is named millet by his name. He is represented by a council millet. Respond number 5. 4. Hanumantappa.
Represented by a council. MV Remat.
Yes.
MV Remat.
Where is MV Remat?
He's on KAT, my lords. He will also appear on this.
Surmata PS.
Kalsurmata.
Kalsurmata, Hiremata.
Kalsurmata will appear.
Who destroyed this?
Respond number 4 millet.
This man?
No, my lords.
Who is he?
He is the executive officer. He is the.
He is the one. What's his name? Hanumantappa.
Yes.
Them.
Yes, my lords. He is not destroyed. There is a proceedings head by the assistant commissioner, and thereafter, on the basis of proceedings, he has acted on that order, my lords. And it is not an ancient monument, my lords.
Sold everything.
No, my lords. It is not an ancient monument.
Alla, idu mandapa ittu. What has happened is these pillars were used. There's a old mandapa that was existing in the premises. Since millet, they wanted millets that to be removed. The pillars were removed from there and stored millets on the other part. That have been cut into pieces and he has sold it outside millet the premises.
Who permitted all this?
Sir.
Lords, my request on
Now
Tuesday,
he
my
wants
lords.
to take advantage of 2017.
Pass over. Ask Kalsurmat to come and ask him to be here. If he has taken it away and sold without any proceeding, I will direct criminal case to be registered against him for taking away government property. That will happen today. That will happen today if no justification comes about.
My lords, may I request?
Think of himself.
My lords, may I request on Tuesday?
Oh.
Learned AG will appear.
No, sir. Yes.
Please.
Ask Kalsurmat to come. Whoever is representing, ask them to come.
Please.
If I find no proceeding and this action being correct, you will watch it. Yes.
2:30.
It is not his personal property to sell it away.
Yes. 2:30, my lords.
2:30.
Yes.
Serial number 2 only, respond number 4, my lords, for the reason they will keep on shifting the burden. Respond number 4 to consider the direction.
Joint and several, sir. Any respondent will consider.
Please.
ನಿಮ್ ಕಂಟೆಂಪ್ಟ್ ಹಾಕಕ್ ತಾನೆ ಬೇಕಾಗಿರೋದು. ಕರೆಕ್ಟ್.
ಅರ್ಲಿಯರ್ ರೌಂಡ್ ಅಲ್ಲಿ ಅವ್ರು ಮಾಡ್ಲಿಲ್ಲ ಅದಕ್ಕೆ.
ಅವ್ರು ಮಾಡಲ್ಲ, ಈಗಲೂ ಮಾಡಲ್ಲ. ಕಂಟೆಂಪ್ಟೇ ಹಾಕ್ಬೇಕು.
ಪ್ಲೀಸ್.
5 ಏನಿದೆ ಕಾಲ್ ದಿಸ್ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್
5.1 may be
KIDB plots, sir.
ಏನದು?
We have paid the amount and they have cancelled the notification itself.
Who has cancelled?
KIDB authorities.
Who appears to KIDB?
I'm for KIDB. The 5.1 may be taken as main matter. I have filed statement of objection on that matter.
All right, give it.
5.1. WP number 105514. I filed statement of objection.
Next year, N is that order.
Allotment ಯಾವಾಗಾಯ್ತು?
Allotment 2021 allotment ಆಗಿಲ್ಲ.
Allotment ಆಗಿಲ್ಲ. Only the
interview has taken
publication has
place.
been issued.
Interview has taken place in 2021. Interval ಆಗಿ ಆಮೇಲೆ they cancelled it in the year 24.
What right of yours is taken?
Please.
What right of yours is taken away?
Amount we have paid the amount, my lord. Even paper, yes.
Amount ವಾಪಸ್ ಬೇಕಾ?
Amount is paid, paper notification has taken place.
Amount ವಾಪಸ್ ಬೇಕಾ ಅಥವಾ?
ಇಲ್ಲ, ನಮಗೆ we want the plot, my lord. After 3 years they cancel arbitrarily.
ಎಲ್ಲ ತಗೊಂಡಾಗಿದ್ಯಾ?
Still if they want money, we are ready to pay also. No. Not about the money. What they say is there is no transparency.
How did you pay?
By
why did you pay?
Online as per the notification, man.
Where is the notification?
Please, man. Next year B, man.
Page.
Please.
Page 15.
Pursuant to this, 22/1/2021.
Please, ma'am.
You made payment,
Please, ma'am.
Ella purti.
Annexure C is the payment.
Annexure?
C.
All right.
And they sent a intro letter as per the.
Sandarshana Patra.
Please. And we attended, even it was videographed. Now what they say is, online nalli application file madilla, online nalli all these things are not taken. There is no transparency. So they make a notification in 24, they cancel the earlier notification.
Where is that? Where is the next notification?
At page number N, my lord.
Page?
N.
Page N.
43.
43 is the letter issued by the KDB.
43.
43? Dandeli Taluk, Ambewadi Auto. So why did you cancel it?
My lord, what happened, my lord? Earlier the notification paper publication has been issued. Subsequently, has to be decided by a single window agency, my lord. I produced the meeting proceedings of the single window agency at annexure R2 at page number 10, my lord. There is no transparency.
Where is no transparency?
In the selection process, my lord.
How did you decide?
There is no document has been produced before the single window agency.
Who did that?
The respondent number joint director and the KDB.
What action have you taken against them? What action have you taken against those officers who are said to be guilty of not following transparency? Yurgen Gut. What action have you taken? You have cancelled this. Cancellation is not action.
No, cancellation not
You
based on
withdrawn
that.
that and issued fresh.
No, subsequently, what happened, my lord? The government has issued circular, my lord. All the pending notices has to be based on the online, my lord. The government circular is page number 23, annexure F, my lord.
Yavag bandidadu?
Page number 23.
Circular yavagindu?
23.
Circular issued on, my lord, 21/6/2024.
When was the applications called?
In the 21, my lord. In the meantime, my lord, some
applications you are applying 24 circular.
Still the finalization of allotment was not done, my lord.
Then how did you cancel it saying that online kotilla? Because online came about only in 2024.
Yes, my lord.
All is not well
Subsequently,
with KDB
what happened, my
here.
lord?
All is not well with KDB here.
Earlier,
fraud.
Earlier, what happened, my lord? Some of the Carpenter Timber Association has filed before writ petition before this honorable court, my lord, saying that they also wants to the lands for allotment. And that is annexure E, my lord, page number 19. This honorable court has disposed on 2022.
Yes, Sanjay Gaudra.
By saying that the grievance of that petition also be taken care of, my lord. Subsequently, what happened, my lord? I have produced annexure R2, the meeting proceeding of the single window agency, my lord, at page number
You should
10.
have placed these applications before the single window agency.
So we have said that the single window agency, my lord, what happened, my lord, single window not accepted the whatever the submission made by the KDB and the joint director, my lord.
So lack of transparency ground in the matter.
In the meeting proceedings, stated like that.
Where is that lack of transparency word here?
Annexure R to page number 10, madam, and along with my statement of objection, madam.
Yavralla hakidare illidiya?
Page number 10, the
KDB ಅಧಿಕಾರಿಗಳು ಯಾವುದೇ ಸರಿಯಾದ ದಾಖಲೆಗಳನ್ನು ಸಭೆಯಲ್ಲಿ ಮಂಡಿಸಿರುವುದು ಏನ್ ಮಾಡಿದ್ರಿ ಅದಕ್ಕೆ? ಆ KDB ಅಧಿಕಾರಿಗಳ ಮೇಲೆ ಏನ್ ಮಾಡಿದ್ರಿ?
The committees, my lord, by the respondent number 6 and KDB, my lord, the joint director
ಮಾಡಲಾಗಿದೆ ಅಂತ ತಿಳಿಸಲಾಗಿದೆ ಎಂಬುದರ ಬಗ್ಗೆ ಅಂದಿನ ಜಂಟಿ ನಿರ್ದೇಶಕರು ಜಿಲ್ಲಾ ಕೈಗಾರಿಕಾ ನಡವಳಿಕೆಯಲ್ಲಿ ನಮೂದಿಸಿರುವುದಿಲ್ಲ. ಪ್ರಕರಣ ದಾಖಲೆ ಯಾವುದೇ ತಡೆಯಾಜ್ಞೆ ಬಂದಿರುವುದಿಲ್ಲ. ಕರ್ನಾಟಕ ಎಸಿ ತೊಗೊಳ್ಳಿ.
Section, see, page number 24, notice has been issued by the joint director.
Petitioners in all these cases are at the doors of this court on the score that the allotment of theirs is stood withdrawn and a subsequent order or notification comes about, calling for applications for allotment for the same places which were allotted to these petitioners. The petitioners in all these cases submit their applications pursuant to a notification issued on 22/1/2021, seeking for allotment of plots coming within the precincts of the Karnataka Industrial Areas Development Board. The petitioners, after the receipt of the applications, were called for interview on on 22/3/2021. All that the petitioners were expecting was the allotment to be taken to its logical conclusion, as every nuance of getting the allotment in their favor had completed by then, as entire amount was already paid. Notwithstanding the same, the KIDB dodges the issue for 3 years. After 3 years, on the score that that allotment made to these petitioners is not transparent, and the officers who made the allotment have fumbled, cancel the said allotment and cancel the notification itself and bring about a new wanting to bring about a new notification. This happens on account of the documents not being placed before the single window agency, which ought to have been placed earlier. Therefore, the entire allotment made to these petitioners are cancelled and the petitioners are before the doors of this court. The KIDB has filed its objections. In the objections, the justification for cancellation of allotment is found in the proceedings dated 18/11/2023. The subject number 2 is with regard to the present allotment.
Subject number 3, my lord.
Subject number 2 and 3. Very 3 na?
3, my lord.
Subject number 3 is with regard to the present allotment. It reads as follows. 10 and 11. In terms of what is indicated, the entire resolution revolves around the allegation against the officers who have not allotted these plots in a transparent manner. The learned counsel appearing for the board is not in a position to answer the query of the court as to what action has been taken against those officers who are said to have played with the lives of these people, of these petitioners, by accepting the application, calling for interview and accepting the entire amount for allotment of a plot. All these are given a go by a stroke of pen by the resolution. All for the reason that some officers have not conducted the allotment procedure in a transparent manner. Therefore, the counsel for the board shall place on record the officers who were functioning at that relevant point in time and what action has been taken against those officers for having played with the allotment pursuant to the issuance of the notification. List the matter on 18th at 3:30 p.m. for further hearing.
5.15. Again, new notification is issued for 2020.
All new notification stay agidya?
Stay agid. That one different matter.
5.15. There shall be an interim order spread for till the next date of hearing.
Serial number 130 also same.
130.
130.
Tag 130 also.
Please.
Yes.
Serial number 6.
Yesterday's election matter, your lordship. Only contention was since 13D is not compliant, whether re-election or suit.
Re-election.
It was regarding one ward, my lords, ward number 7.
Right,
In respect
we
of
upset
other
the apple
wards.
cart by doing this.
Only one illustration, if your lordship permits. If at all, if your lordship re-election was ordered since 13D is not complied. Admittedly, Your Lordship, in all the writ petitions we filed for seeking voting right and contesting right,
Correct.
ಎಲ್ಲದರಲ್ಲೂ 13D ಆಗಿರಲ್ಲ.
ಹೌದು.
Already, Your Lordship, nowadays contesting right is denied, only voting right is given. If all writ petition is allowed and re-election is ordered, all the petitioners will come to the court and for the same, attaching the same order, they will seek for re-election. And now, Your Lordship, for conducting re-election, it will take another 10 to 12, 1 year, Your Lordship. Already 1.5 years is over.
So ಈಗ ಏನ್ ಮಾಡೋಣ?
2.5 ವರ್ಷ ಆಗ್ಬಿಡತ್ತೆ. And again, Your Lordship, re-election is conducted also, 13D notices given also. Again, the same 5 members will be eligible because another 74 will be ineligible because all are defaulters and some other are not attended the meeting.
Already manage ಮಾಡಿದ್ದಾರೆ.
ಸೂಟೇ ಬೆಟರ್. ಸೂಟ್ ಕಳಿಸಿ.
Please, since
ಯಾರು
with
object
respect of
ಮಾಡ್ತಿದ್ರು?
declaration of result, Your Lordship.
You are objecting to the
ಇಲ್ಲ,
order.
ಇವ್ರೇ.
ಅವ್ರು ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Members lordship.
ನಮ್ದು ಒಂದೇ ವಾರ್ಡ್ ಒಬ್ಬನೇ ಕಂಟೆಸ್ಟೆಂಟ್.
ಅಲ್ಲೇ
My lordship,
ಒಂದು ವಾರ್ಡ್ಗೆ
liberty, I will declare the result.
ಒಂದು ವಾರ್ಡ್ಗೆ will not.
ಇಲ್ಲ, ಒಂದಲ್ಲ ಇನ್ನೊಂದು ಇರ್ಬೇಕು ನನಗೆ.
He is right.
ಅಲ್ಲ, rights of the
Very
party.
starking illustration.
Rights of parties and they have filed writ petition for 25 members. There is another writ petition which is already disposed for the same ward. There is 31 members, majority.
Rights of the parties as to because
ಎಲ್ಲ ಅಲ್ಲೇ. You agitate every issue there. Same order. Shyam Prasad Sahib.
at least lordship because what has a ಅವರು
ಇಲ್ಲ ಅಪೀಲ್ ಹಾಕೊಂಡು ರಿವರ್ಸ್ ಮಾಡ್ತಾರೆ. The petitioner is before this petition, ಎಷ್ಟು ಮ್ಯಾಟರ್ ಇದೆ? ಒಂದೇ ಎರಡ?
ಎರಡು.
Petitioners are before this court seeking the following prayer. Owing to the prayer sought by the petitioner, this court had granted an interim order in each of these cases which read as follows. The interim order was restricted to voting rights of these petitioners. Now the elections are over and what is necessary is counting of those votes. In identical circumstances, when voting rights were granted, the coordinate benches of this court have been consistent in their view, which has been followed by this court, that the parties to be relegated to
submission. Elections are not over. Admittedly, they are given endorsement also. In other matters,
that we'll
elections
see in so and so. The learned counsel ML1T appearing for the petitioner seeks to contend that there is no elections held and there is a communication from the hands of Yaridu?
Second respondent.
A communication from the second respondent. Per contra, the another communication is new kotidadu. Another communication is placed on record which observes that the elections are indeed held and in the light of the interim order granted, no further proceedings are taken. In that light, all these would be a question of fact or to be thrashed out by evidence. In that light, the orders that are generally passed by the coordinate benches of this court and this court with regard to the election, with regard to the dispute, with regard to the liberty being reserved to these petitioners to raise a dispute under section 70 of the Cooperative Societies Act, keeping all the contentions open. The the Shyam Prasad Sahib order, you are quote madi. The coordinate bench is held as follows. In that light, leaving open all the contentions, the petition stands disposed.
In both petition, Your Lordship, for returning officer, G.V. Baramgowda appears here.
ಹೇಳಿದಿವಲ್ಲ ಅಲ್ಲಿ ಇಲ್ವಾ?
ಇಲ್ಲ, one petition ಅಲ್ಲಿ ತೋರಿಸಿಲ್ಲ.
ಆಯ್ತು, ಬರಂಗೌಡ್ರು ಎಲ್ಲೆಲ್ಲ ಅಲ್ಲೆಲ್ಲ ಹಾಕ್ಬಿಡಿ ಅವ್ರು.
ಇವ್ರು ಸಬ್ಮಿಟ್ ಮಾಡೋ ಎಲೆಕ್ಷನ್ ಬಗ್ಗೆ ಹೇಳೋದು, ನಾಮಿನೇಷನ್ ಬಗ್ಗೆ ಹೇಳ್ತಾರೆ.
ಯಾವ್ದು ನಾಮಿನೇಷನ್?
ನಾಮಿನೇಷನ್ ಬಗ್ಗೆ, ಎಲೆಕ್ಷನ್ ಬಗ್ಗೆ ಹೇಳಿ, ಇಲ್ಲ ಕಂಡಕ್ಟ್ ಮಾಡಿರ್ಬೇಕು.
ಇರ್ಲಿ, ಎಲ್ಲ ಅಲ್ಲೇ ಮಾಡ್ತಾರೆ. ಇಲ್ಲಿ ನಾ ಎಲ್ಲಿ ಮಾಡ್ಕೊಂಡು ಎಲೆಕ್ಷನ್ ಮಾಡಿ
ಅಲ್ಲಲ್ಲ, ಡಿಸ್ಪೋಸ್ ಮಾಡಿ ಎಲೆಕ್ಷನ್.
It is needless to observe that since the issue pertains to elections, the ARCS,
Please, under 70.
ARCS shall expeditiously dispose the matter in terms of the mandate of the statute.
Announcement of result, Your Lordship, since only candidate has demand, ಅಲ್ಲ ಅವ್ರು ಅನೌನ್ಸ್ ಮಾಡಬೇಕು.
ಅದೆಲ್ಲ ರೇಸ್ ಮಾಡ್ತಾರೆ,
ಎಲ್ಲ ಅದರಲ್ಲೇ ಮಾಡ್ಕೊಂಡು.
ಅಲ್ಲ, one petition ಅಲ್ಲಿ subject to leave of this court ಅಂತ interim order.
ಆಯ್ತಲ್ಲ, ಕೊಟ್ಟಾಯ್ತು ಎಲೆಕ್ಷನ್ ಫಾರ್ ಅನೌನ್ಸ್ಮೆಂಟ್ ಆಫ್ ರಿಸಲ್ಟ್ಸ್. ಯಾರು ಇಲ್ವೇ ಇಲ್ಲ, ಅವ್ರೊಬ್ಬರೇ ಇರೋದು.
ಅಲ್ಲ,
ಎಲೆಕ್ಷನ್ ಬೇಕಾಗಿಲ್ಲ.
79 ಒಬ್ಬರೇ ಬಂದು ನಾನು ಒಬ್ಬನೇ ಅಂತಂದ್ರೆ.
Yes, yes.
Please.
Number 7, Pavan V. Toddati, Girish Yadva.
Day before yesterday's matter.
ಗೊತ್ತು.
CR made a submission that, Lords, he doesn't happen to be a co-sharer, and even insofar as adjoining landowner is concerned, Lords, law is settled
that it violates, my lords, Article 19(1)(e) of the Constitution. And on that point, my lords, he is not eligible to
That
file.
requires evidence. Next question.
Even by going through the pleadings itself, my lords, I can make out.
All that you are now projecting is your defense.
Lords, now their pleadings itself says that they are not.
Not consider your defense and say 711 should be allowed.
By going through their own pleadings, my lords, I am submitting.
As simple as that.
If lords may kindly see their plaint, my lords, at page 22, para 5. They say, my lords, that my ancestor is one Rajasab. Para 5, my lords, there is a genealogy produced.
Page?
Page 22, my lords. Last para.
You are adjacent landowner.
Please.
Howda?
Adjacent land.
Hand sketch is also more produced.
How are you getting into this?
Yes, my lord. As I submitted, if my friend has completed.
Right.
Yes, there are three categories who can seek preemption. One is, my lord, the co-sharers. Second is, my lord, any person having a right of any easementary kind, that is, my lord, right of way or whatever nature. But admittedly, there is a pathway passing through both of our lands. In between, his land is situated. On top and on bottom, at bottom, my lord, my land is there, and there is a house.
Now, suit for what?
Preemption. He has executed sale deed. Immediately, I demanded. My lord, that's what it says, my lord. Under Mohammedan law, completion of sale deed is a requisite. After that, my lord, I can.
One more submission, my lords. The purchaser is a Hindu, my lords. The right of preemption can be claimed by a Muslim against a Hindu.
It's not against him, it's against the Mohammedan.
Calcutta and, my lords, Bombay High Courts have held that, my lords, it is not permissible.
All parties should be Muslim, my lord.
All parties should be Muslims.
Tricky question. See.
It is for me to establish, my lord, under
So far
which
as,
of the
lords,
three
adjoining
categories I
landowner,
come.
lords, our own court has held that it is violative of Article 19(1)(e).
That is on vicinage, my lord, that only on the ground that he is adjacent landowner, it can't be.
Right of preemption based on vicinage and under Mohammedan law is void as it violates Article 19(1)(e) of the Constitution of India, which guarantees the freedom to reside and settle in any part of India.
We'll see. We'll answer it. Anything else?
Please.
My lord, sir, if I may rely on.
And lords, there is a delay, lords, in filing the suit also. 12/1/22 is the sale deed. And 19(1), lords, he says he got to know the sale deed was executed. And lords, on 3/2/22, he has filed a suit. A minute delay has to be considered as fatal to the case, lords.
We'll see.
Please.
Yes. Both will answer.
Please.
Reserve.
May I,
What's the next date?
Please,
Next
lord,
date.
it is for hearing on IM, lords. He has filed an injunction application. So
When
it
is
for-
that?
Date I have to.
Stay jail.
It may be extended, lords. Till today it was there.
Reserved. Kudi, ella kudi.
Please.
Two judgments. On 7 Rule 11, my lords, if there are triable issues, should not be rejected. My lord, a recent judgment in Vinod Infra, that is the first one. And the other one is, my lord, limitation. It's a mixed question of fact.
ND.
Yes.
ಯಾಕೆ ಇದಿಲ್ವಾ ಪ್ರಿಂಟ್ ಇತ್ತಂದಿಲ್ಲ
ಇಲ್ಲ